don't see the light coming on, but I see, there we are. All right, good evening, ladies and gentlemen. I'd like to welcome you to the continuation of the Development Commission special meeting concerning the Issaquah Highlands Retail, Issaquah Highlands Medical Office Administration, Administrative Site Development, and the Issaquah Highlands Self-Storage Administrative Site Development Permit, a continuation from our November 29th, 2018 meeting. And so with no further delay, I'll turn the time over to Mr. Lell, who will continue us on.
Thank you very much, Mr. Chairman. I believe that the next order in the proceedings is for Mr. Schneider to begin his cross-examination of Ms. Sloman, the city's witness. But before that, there is one procedural or preliminary point that I would like to address. During the most recent hearing, it was requested that the city provide copies of the polygon agreement that was referenced in Mr. Niven's testimony, and the city has made copies of these two documents, which we'd like to introduce as C33 and C34. And we would be happy to introduce or to recall Mr. Niven to provide context for these materials, or we'd be happy to do that at a later time during a rebuttal opportunity.
Why don't we wait? Why don't we wait until the rebuttal?
Thank you. I'd be happy to do that then. Thank you.
So, do you need to remind Ms. Sloman of her oath?
Yes. Ms. Sloman, if you could please take the stand.
Thank you.
Thank you. As a preliminary matter, could you please confirm and acknowledge that you continue to be under oath from your original testimony?
I continue to be under oath.
Thank you.
Sloman, why don't we start with the documents that Mr. Lell has just introduced. I would note that C33 is the same document as S5 that's already in the record, and that C34 is a signed version of the development agreement that is part of C33 and is also in the record in the unsigned version as part of RS5. So both documents are in the record. The change is that we now have a signed version of this second development agreement. So, Ms. Sloman, these are the documents that Mr. Niven identified as explaining why the city processed Polygon's application submitted after the termination of the development agreement under the procedures and standards in the development agreement. Do you agree? That's a fair characterization of his testimony?
That these are the documents that were the basis for processing those land use permits?
Yes.
I believe so, yes.
Can you identify for us in either document where it says anything about vesting Polygon to the expired regulations and procedures in the earlier development agreement?
I was not party to developing these. Mr. Niven answered those questions. I think if you have additional questions, you need to ask Mr. Niven.
Well, am I correct in understanding then that you are not aware of any basis in either document for treating Polygon as vested to the expired development agreement?
I'm not saying that. I am not the expert on these documents, and I am not going to try and explain them to you.
Well, I'm asking whether you're aware of anything in them. It seems to me either you are or you are not. Are you aware of anything in either document that would justify how you treated Polygon under the expired development agreement?
I understand them to be a development agreement related to certain properties, and as that I believe understood to be the basis for how they were handled. If you're asking for specific provisions, I think someone who is familiar with these documents would have to answer that question.
Well, Mr. Niven, I believe, said you would be the person because he wasn't familiar with them, but he identified them. So
I don't believe he said that. I did go back through the record. Mr. Niven was the primary author and took these documents through council. He is the one that has the familiarity and I think would be best able to answer those questions, which is why I believe Mr. Lell offered to make Mr. Niven available if there were follow-up questions.
So why don't we turn to and compare, if you would please, your two charts that you did talking about the timelines for processing Shelter's application. The first one is the one you prepared for the City Council, which is S6 in the record. And the second chart is the one that you prepared for this hearing, which was C27. So we have up on the screen C27. Why don't we start with it? So I'd like to walk through and have you explain for us where these numbers of days come from. And let's start with the column you've identified, pre-plat, and you say 117 days. How do we get to 117 days?
So back in the late 90s, as we were beginning to develop or implement the development agreement, Port Blakely Communities, the master developer, and the city found the exhibit, which was from Appendix L. I don't remember what exhibit number it is that was introduced last time.
C28, the one that follows this one.
Okay, thank you. C28, that chart found it difficult not only for city staff and the master developer, but for applicants. And so city staff undertook to develop individual charts that were trying to explain for different land use types how the steps and timeframes rolled out from that Appendix L chart. Those were developed, as I said, about 2 decades ago. The master developer and city have used those since then as a way of explaining both the timeframes and steps.
Well, where are these documents that you're now referring to?
I have them in my office. They were never formally adopted. They were used as tools by, as I said, the master developer in the city.
Okay, well, I would request that you provide those to Mr. Lell and ask that he provide them to me before the next hearing.
Certainly.
Is it fair to say, based on what you just testified to, that the numbers of days that are in C27 are not the number of days that are in Appendix L to the development agreement?
No, we considered those that for instance, the 117 days was our understanding of the Appendix L chart and how the steps and dates in that Appendix L chart worked for in implementing Appendix L. There was no intent to change.
Well, why don't you turn the page then to the next exhibit, C28, and explain to us how you come up with 117 days for getting from submittal to approval of a preliminary plat.
I haven't studied this in a long time. I believe that it is looking through combining both the Grand Ridge Commission, which has to make a recommendation on a preliminary plat, as well as City Council. I think the best way to explain it, rather than trying to work through this document and explain, is to provide that chart for you to look at the basis on which we calculated that 117 days.
And I would like to see that chart. Rather than have you walk through this document, is it fair to say, just so that we understand how to interpret it, that each step, for example, if we look under the column for the Grand Ridge Commission in the middle, it has between submit preliminary application and project feasibility meeting, it has 10 days. And then if you go down further, submit application or request including SEPA documentation, you have another 10 days to complete application decision. So if we go, am I correct in understanding that if you go through this development and add up the number of days that are between those boxes, we'll end up with 117?
That's my understanding, and that was how we took the chart and tried to pull apart the various permits to calculate what that number of days was.
Okay. And the same thing would apply if one were trying to calculate the time periods for the columns called administrative and city council. One would add up the days that are in parentheses between the boxes.
Yes, although with a preliminary plat, for instance, then you have to continue to the council column.
In order to get the final plat.
Yes.
Yes. So, okay, so let's go back for a moment then to your C27, the prior page. Why is there anything on here about, there's the third column about final plat. What does the final plat decision have to do with the processing of the shelter's administrative site development permit or its other site development permit?
So there is a preliminary plat followed by a site work permit, which is your infrastructure improvements, followed by a final plat. And the parcels that the land use permits are being placed on would not exist until that final plat had been recorded.
And why does, and what effect does that have on the processing of the applications for SDP, ASDP? If you look at your fourth column, you have processing times there that begin the day after final plat approval, correct?
I do, but those, that date, 3/18, is also the date on which the complete letter agreement was approved, coincidentally.
Well, I'm not asking about the letter agreement. The point is that you have the processing of the STP applications beginning the day after final plat approval, correct?
That is one way to read this chart. It is also the day on which they were deemed complete, which would be the day on which you would begin the processing if you were going straight into land use permits.
Well, what I'm trying to find out is it your position that these SDP, ASDP applications you could not begin processing them until final plat approval was obtained?
Well, I couldn't begin processing them until they were deemed complete.
I'm sorry, can you say that again?
I could not begin processing them until they were deemed complete.
And I'm not asking about them. I'm asking you whether it is your position and whether this Exhibit C27 is intended to state that they could not be processed until the final plat was approved.
Well, they couldn't be processed unless they were deemed complete.
You're not answering my question, Ms. Sloman. Let's leave aside for a moment the question of completeness. Is it your position that the applications could not be processed until final plat approval was obtained from the City Council?
In the letter agreement that was approved on March 18th, there was the potential of processing them after the final plat was approved, using the timeframes in that letter agreement.
Ms.
Which-
Sloman? I'm sorry, I didn't mean to interrupt. Go ahead.
Based on the information I had, there were two scenarios that were laid out. One was through the completeness letter, processing them after the preliminary plat using the timeframes in the letter that Patrick Mulaney from Foster Pepper drafted, or if we were processing them based on when they were deemed complete, it coincidentally happened after the final plat was approved.
Ms. Sloman, is it not in fact true that the letter agreement was required because you were refusing to process the SDP applications until there was plat approval?
The sufficiency checklist had elements that included legal descriptions, lot lines, right-of-way, and easements. Those materials were not available and because the plat had not been completed. My concern was that there were elements that were shown in the preliminary plat, which if they were not approved, would negate certain aspects of the land use permits. For instance, I believe required, I'm doing this from memory, I haven't looked at these in a while, but my memory was there was something like an easement or other provisions that existed when the plat was submitted, which would have, if they had not been lifted through the platting process, would have precluded locating required parking where it was shown in the land use permit. And so there was a concern that we were being asked to process land use permits in ways that were not consistent with our submittal requirements and which seemed to leave a lot of variables on the table when we were being asked to render a decision.
Okay. Ms. Sloman, does that mean the answer is yes, you were refusing to process the SDP, ASDP applications unless, absent this agreement, unless there was final plat approval?
I was not refusing. Patrick Mulaney from your office and I had quite a few conversations because I was concerned that I was being asked to agree that certain things existed and were fixed, which at the time, because the preliminary plat and final plat had not been approved, were concepts. They were not real right-of-way locations, were not approved property lines, and easements had not been lifted.
Again, Ms. Sloman, does that mean you were refusing to process the application or the SDP, ASDP applications unless there was plat approval?
I'm not comfortable with the word refusing. We were trying to have a conversation about the discrepancy between the submittal requirements and the materials that were being submitted.
Well, you just referred to a discrepancy. What was the discrepancy?
The submittal requirements ask for right-of-way, location of right-of-way lines, legal descriptions, lot lines, easements. The things that were being shown in the land use permits were proposed right-of-way, proposed lot lines, proposed legal descriptions, proposed easements or removal of easements. And my concern was that we were being asked to render a decision which we would be held to with a lot of variables that we did not know if those would actually be proved in the form in which they were shown.
So, Ms. Sloman, according to the timelines in the development agreement, for example, if we turn back to the city's exhibit, shelters exhibit, that's 6, timeline that you prepared for the city council on March 19th, the preliminary plat should have been approved when?
So I'm not comfortable with the word should. If we used the number of days that we had calculated that Appendix L showed, and if we did that as if everything was perfect, we needed no additional information, there were no corrections, it would have been approved on November 26th. However, as we've seen, we asked for additional information and corrections with the preliminary plat. And so that date is a concept.
So, Ms. Sloman, the notice of application that your department gave for the preliminary plat is entirely consistent with SDP applications that we're talking about, correct?
Could you ask that question again, please?
Yeah, I'm asking you to take a look at Exhibit S1, which is the notice of application that your department gave for my client's preliminary plat application. And if you turn to the second page of that, that's the page that shows the site plan, shows the rights-of-way, it shows the parking, it shows the building footprints, as we've already heard testimony about. Is there anything about Shelter's SDP applications that is inconsistent with page 2 of the notice of application you gave for their short plat, or for their subdivision?
I don't know that whether it's consistent or not is the relevant question, because
Sloman, I'm not asking you your opinion about what's relevant. I'm asking you, is there anything in there that isn't consistent?
this is not an approved preliminary plat. It may match the SDP, but that doesn't mean that it would be approved in this form.
Does it or does it not match the SDP applications?
I don't know. I haven't done that comparison. I would not be able to answer that without comparing it.
So you've had this application for almost a year, and you haven't compared it to the SDP applications to see whether there's any consistency or not?
We're still waiting for information on the preliminary plat. We have asked for corrections and for additional information. Some of that may change what is depicted here.
Okay, I have a new exhibit I would like to offer, please. This would be S11. You take a moment to look at it. This one is single-sided, so that should be the official exhibit copy. So if I get that one.
This is S, right? Yes, change.
You recognize this document?
Yes, parts of it.
So it's an email exchange, this is not email thread between your staff and you and Ms. Hine?
Yes?
Okay, so why don't we start at the back, which is where the earliest emails are on the thread, and work towards the beginning. So what's the first email dated April 13?
Did you ask what's the date of the April 13 email?
No, I asked you what the email was that has that date.
Oh, it's from Ken Shipley at Core Design to city staff and others, asking to follow up on a few items discussed at the meeting.
And why don't you read the first sentence to us?
I want to follow up on a few items discussed at the meeting and for which we're awaiting answers, information, or action from city staff.
And do you remember the date of the meeting to which he's referring?
No.
Okay, so what is your department's response and from whom in the next email?
Thanks for your patience. We've been working on a comprehensive response to the follow-up items from our meeting and your answers below, and we'll be getting back to you tomorrow.
And who's that email from?
Jean Lynn, who works for the city, to Ken Shipley et al.
And you referred to Jean Lynn last time in your testimony as a senior planner, is that correct?
That's correct.
And how many years' experience does she have?
I don't know exactly.
Okay.
I don't remember.
It's close to 20, isn't it?
Unless I looked at her resume, I don't remember.
Okay, and she's been assigned to IHIFC's applications from the outset, correct?
Yes?
She didn't come or go. She wasn't one of the staff people you had to hire.
Yes, she was.
Well, she's been part of IHIFC's applications from the beginning, correct?
Yes, she
And it's still-
started in June 2017, and the application came in August 2017.
Okay. And then why don't we, so when does she respond then, more substantively, to the request?
April 18th?
Okay, and then if we can turn over to the next email, which is from Tia Heim on behalf of IHIFC, would you read the first paragraph of her email?
So this is from Tia to Jean and others. Jean, we are puzzled and concerned that the city has again changed direction that it is giving us with respect to rights-of-way and trail connections that will be required within our plat, as well as with respect to the scope of the transportation analysis and information that will be required. Are you asking me to read the full paragraph?
Yes.
We are even more concerned that many of the comments that you provided are not consistent with the development standards set forth in the development agreement to which this application is vested. The city has acknowledged that our subdivision application is vested to the development agreement, but the city appears to be ignoring the standards in that agreement in the requirements it is imposing on us. We request that you provide response to the following questions and comments.
Okay, and then what is the next email?
Tia on June 6th.
So he made that request on April 26th, and she's following up on June 6th. What does she say then?
Please advise as to when we can expect a response to my email below, as we are unable to revise and submit our preliminary plat application without clarity regarding the city's additional comments and corrections in your email below.
And then what's the response from Ms. Lynn?
On June 8th, Jean Lynn says, we are still working on these items and we'll be getting back to you with our responses next week. Thanks for your patience.
And then what's the next email?
June 29th, from Tia Heim to Jean Lynn, just checking in again to see how you're coming on the response to my email from April below. If you could let me know when we can expect a response, that would be helpful.
And Ms. Lynn's response to that is dated when?
July 18th.
And what does it say?
We are in the process of finalizing our responses and aim to get those to you at the end of this month.
And what's the next email then?
August 16th, from Tia Heim to Jean Lynn.
And what does it say?
Following up again to check on timing of your response to the questions in my email from April. Your last email indicated that we should expect a response by the end of July, and it is now mid-August. Please advise as to when you anticipate being able to provide a response so that we continue to move our plat forward.
Okay, and then what's the next email? It appears to be from you.
It is. It's from me to Tia Heim on August 16th. And I said, I apologize, this has taken longer than anticipated. We had some coordination with other departments and some research to answer your questions. I commit that you will have it next week before I go on vacation the last week of the month.
Okay, and then what's the next email?
August 24th, from me to Tia, attached are the following.
Okay, so I understand from this that on August 24th, your department responded to the questions that were initially asked in April, correct?
No. I believe that there was an initial response on April 18th from Jean Lynn, and to that, Tia Heim responded asking a lot, or not, I'm sorry, not June 6th, April 26th, asking a number of additional questions, and it was that email that generated a lot of research and coordination on our part to respond to the depth of questions that were asked.
Okay, so on April 26th, Ms. Heim asked questions that your department responded to in substance on August 24th, correct?
Yes.
So we have slightly over 4 months in which my client couldn't do anything because you hadn't responded to their request. Is that fair to say?
We were trying to do the research and answer the depth of questions that were being asked, and that took more time than we anticipated.
Okay, well, we've heard we've heard comments about how the delay is my client's own fault. Are you attributing this 4-month delay to IHIFC?
We were simply trying to respond to the complexity of comments and research that was requested in a thorough way.
And what was complex that required a 4-month research time to respond to?
Well, there were, for one thing, I wanted to ensure that the comments were thorough, which meant that I had to understand the basis that the staff had given, because clearly the April 18th response was not sufficient for your client. There were requests to provide all the modifications that had taken place to certain road standards, which meant going through 20 years of records to determine which standards, which decisions had modified those standards. There were questions about whether other projects had, I believe there were questions about whether other projects had utilized or how they had been treated. We had to go and look at those records. We were trying to provide a thorough response.
So you testified last time that ball's in my client's court today, and you can't process the plat application because you're waiting for a response from them. Is that correct?
Yes.
Okay, what are you waiting for?
Well, following the August 24th letter, we received another email response from Ms. Heim, which is the one on the cover, October 10th. I have been working on the responses to those and expect to have them out in the next week or two.
Well, I think what you just said is that my client is waiting to hear from you, not the other way around. Isn't that what you just said?
In response to this email, yes, but we do not have any drawings resubmitted. So we are attempting to answer the questions and provide the information that your client is asking so that they are ready to resubmit their drawings.
So what request to my client have you submitted for additional drawings?
In, I believe it was January and March, comments were sent on the drawings. We use a electronic plan review, and on those drawings were questions, suggestions, clarifications. I don't have the list of comments in front of me, so I am assuming those are the kinds of things that were included in that letter to your client.
Well, what I'm asking you to identify, if you can, is what communication has been given to my client to tell my client what it needs to do for you to continue processing the application that they submitted 15 months ago.
So, as I said, in January and March, I believe, I'm doing this from memory, there was a correction letter sent to your client.
Okay, well, is it fair to say that the October email from Ms. Heim is explaining to you that they need more information in order to understand what you're asking for?
Yes, they are asking for questions and they are providing us with additional questions and clarifications.
Well, they're asking you to clarify what you want so they can respond, correct?
No, I'm not sure they're asking what we want. I think they are challenging some of the materials that we provided or requests that we made, trying to understand the basis as well as the standards.
And is what you just said, is that a characterization of the email and exhibit S11 that we've just been talking about?
Could you ask that again, please?
I'm asking if the testimony you just gave is your characterization of Ms. Heim's email, her last response in the email chain we've been talking about.
Well, I think it's over the course of this series of communications, there have been both requests for clarification and questioning the basis for some of the things that we have asked for.
And what I'm trying to understand is if your testimony is based on Ms. Heim's email, which is the last one in the chain we've been talking about, or whether there's another document that you are talking about.
So as I have responded to Ms. Heim's questions and requests, I have created a separate document that assembles her requests and our responses into a single document for easier understanding and referencing. So some of the response is in this email, and some is in that document, because I think it's important to understand, be able to see both the questions and the responses as they're unfolding.
Well, is the document you were just referred to and described something that's been given to my client?
Yes, it's how I respond to her. It was, for instance, in my August 24th response, I say, attached are the following: our responses, the administrative minor modifications, and then a link to a SharePoint site.
Okay, and again, all I'm trying to do now is make sure we have the universe of documents. So you're saying if we pull up the attachments to that email, that will be the universe of communications to my client about the city's expectations?
I'm not sure there are expectations. I think there are responses to your client's questions and requests.
Ms. Sullivan, I'm trying to determine whether we have all the documents identified. I'm simply, if you want to challenge my characterization of the document, that's fine, but please answer the question: are there any other documents other than the email and the attachment to it?
The email and the attachments to it are together. That is the things I am referring to.
Okay, thank you. So let's go back for a moment to the chart you prepared for this hearing, C27. You have final plat approval March 17th. You have the, let's do the medical office building, the center column. Medical office building processed over a 50-day time period and approved on May 7th, correct?
This is, as I said, straight processing time that does not take any requests for information, for clarification, or corrections into account.
And the time periods on here are obviously, all three of those time periods for the retail, the MOB, and the storage are shorter than the April to August time period in which my client was sitting waiting for you to respond to their questions about the plat application, correct?
I don't understand the relationship between those two.
Well, you've shown a relationship on this chart between plat and SDP, and in part, I'm trying to understand what you think the relationship is. Is there a relationship, or is there not?
The plat, we sent out for corrections, and we are awaiting resubmittal. We recognize that there is a conversation going back and forth for clarification prior to your client resubmitting. The land use permits that are shown here have been on a separate timeline based on responses from you and your client.
Okay, is it, and I apologize if you've answered this question, but the agreement that you referred to on March 18th, that again was necessary because of the explanation you've already given us that you were concerned that the information shown on the plat didn't yet exist, correct?
Yes? Yes.
And you, in fact, approved a short plat application for Polygon months after you approved the SDP application for the same project, didn't you?
I'm sorry, which same project are we referring to?
I'm referring to the West Ridge Townhomes 1 South Polygon application that your department approved on July 19th of 2016, even though you didn't approve the short plat that created the lot on which that project was located until the January of the following year?
I don't have that material in front of me, and I am unable to answer without looking at those materials and reviewing the timelines.
You don't have any recollection of doing that?
I remember that there were permits processed at that time. I don't know exactly which lots were created in which way and at what time and how all those pieces fit together.
Is it your belief that you have treated IHIFC's applications in the same way that you have treated Polygon's applications?
Yes.
So how is it then that Polygon's West Ridge North single-family plat application excuse me. Polygon's Westridge Townhomes North application. The names are very confusing, and I apologize to the extent I'm adding to them, but the Westridge Townhomes North application was submitted on October 20th of 2017. I'm not expecting you to remember the exact date, but you recall that application being submitted after the end of the build-out period, correct?
Yes.
And that application was processed under the procedures in the development agreement, correct?
Yes.
And in fact, the application was approved in May of this year under the procedures and the standards in the development agreement, correct?
Yes.
But your testimony is that you're treating IHIFC and Polygon in the same fair and reasonable manner?
If the question, it seems to imply that we should not be using the Issaquah Highlands Development Agreement, and I think that speaks to your original set of questions regarding the affordable housing and TDR agreements that Westridge undertook and which were approved by council, which was the basis for which set of regulations applied to them.
Well, so you're saying that the Westridge Townhomes North application, the one I just described, is also processed under the development agreement because of exhibits C33 and C34?
Yes, I assume so, but again, I defer to Mr. Niven, who has a far greater expertise in those documents than I do.
Okay, I asked the question because I thought it was only the Westridge Block 4 affordable housing application that was processed under the already expired development agreement because of these exhibits C33 and C34, but it's your understanding that that is also the justification for Westridge Townhomes North application?
Yes, because there's affordable housing in that project.
Okay. So, okay. Can you explain any other reason why Polygon's application, other than whatever Mr. Niven identifies in Exhibits C, 33, and 34. Other than that, is there any other explanation you're aware of for the disparate treatment of Polygon and IHIFC?
That's your characterization. I'm not saying that it was disparate.
You processed one under the development agreement, and you're processing my client under the replacement regulation. So why don't we assume that that's disparate treatment? And I'm asking if there's any other explanation or justification other than whatever Mr. Niven can identify in Exhibits C33 and C34.
I think this speaks to vesting and which set of regulations apply to each set of permits based on the vesting provisions that the council adopted.
Ms. Solomon, I don't understand how that was responsive to my question. I'm simply asking, are you aware of any other authority, explanation, justification for processing Polygon under the development agreement and IHIFC under the replacement regulations other than Exhibits C33 and C34? I think you can answer that yes or no, and if the answer is yes, then you can tell us what the other authority is.
So if I'm understanding your question, I believe that we're saying that C33 and C34 applied to Westridge North Townhomes and linked them to or placed them under the Issaquah Highlands Development Agreement, while the replacement regulations that the council adopted apply to your client's site development permit.
Ms. Solomon, I'm asking you whether there's any other explanation, authority, justification for processing Polygon under the development agreement and IHIFC under the replacement regulations besides Exhibits C33 and C34. Is there or is there not?
I thought I just answered that question by saying that the replacement regulations applied to your client's SDP.
Okay, so why that, with all due respect, begs the question. Why do the replacement regulations apply to my client and not to Polygon? Is there any explanation other than C33 and C34 that you can identify?
So it is the documents that were adopted in association with the transfer of development rights and the affordable housing agreement. I am not an expert on those, and I feel very uncomfortable saying that these are the absolute only documents. That's why I've asked for Mr. Niven to answer these questions.
Well, and I'm deferring questions about the content of these documents until Mr. Niven returns. I'm asking you whether you're aware of anything other than these two documents that you're asking Mr. Niven to explain.
Well, as you saw at the last meeting, there was some confusion about the full universe of documents that applied, and there was a map that Mr. Niven provided via Mr. Lell. There are these documents. I do not feel comfortable that I know the full universe of documents to say that C33 and C34 are the only documents.
All I'm asking for is what you, as the land manager, are aware of. Are you aware of any other documents?
I would have to do research to feel comfortable answering that question under these circumstances.
As you stand here tonight, Ms. Sloman, are you aware of any other documents that explained why your department processed Polygon's application for the West Ridge Townhomes North project under the development agreement process and regulations and is refusing to do so for my client?
Refusing is not the word I would use, and let me finish. There are also major amendments to the WashDOT TDR agreement and the Issaquah Highlands Development Agreement that I am not familiar with, and I don't know if there are any provisions in there. So that's why I'm uncomfortable making the declaration that you're asking me to make.
All I'm asking you to tell us is what you know, Ms. Sloman. I'm not asking.
Mr. Snyder, I think that you've adequately asked the question, and Ms. Sloman has done her best to respond as appropriately as she feels comfortable doing it. I think continuing on that same question now about the fifth time would not be very profitable.
Are you familiar with the vesting provisions of the development agreement, Ms. Sloman?
Of the replacement regulations or of the Issaquah Highlands Development Agreement? Or of another development agreement?
Well, the only development agreement I'm aware of that says anything about vesting is the Issaquah Highlands Development Agreement. Are you aware of another?
No, it's just you said development agreement. There's been some confusion around the agreements that the development agreements that Polygon executed, and I want to make sure that I'm answering the question you're asking me.
Okay, well, let's assume that if I don't say otherwise, anytime I refer to a development agreement, I'm referring to the Issaquah Highlands Development Agreement. And my question is, are you familiar with the vesting provisions in it?
I think you'd have to tell me which provisions you're referring to.
Well, I'm referring to section C23. We could bring that up, please. That is called vesting in the development agreement.
C23 is a sufficiency letter?
referring to the section of the development agreement, which is 3. So let's start, section 323 as a whole. Are you familiar with it?
I have read it.
Okay. And when did you first read it?
Around the time that the consulting firm that I worked for was hired to provide staff services to the city of Issaquah,
Can you approximate what year that was?
probably 1996.
1996. So you've been aware of this language for, what, 22 years?
Something like that.
Okay. Could we scroll down to 323, I think it's 2? The section called after build-out. Can you read that for us, please?
3.23.2 after build-out. The development standards shall continue to apply to all applications for implementing approval submitted after expiration of the build-out period, except either party may terminate this agreement and the zoning and development regulations may be modified as provided in section 5.13.
Okay, then we're going to offer a new exhibit. S12.
I think you may have, it's quite thick. That's all right. Thank you.
Thank you. You keep my A11.
I'm sorry,
Sorry, we're going to put it up here. I think I need to use
Mr. Schneider, could you clarify again what the number of this exhibit was?
this. I think it's going to be C12.
Thank you.
S12.
S12.
You recognize S12?
Yes,
Is this a PowerPoint that you prepared?
yes.
And who did you show this PowerPoint to?
Well, it doesn't say on the front page. I believe February 7th was the Land and Shore Committee, but I am guessing.
Okay, my understanding is that the 7th was a community meeting and the Land and Shore Committee was the next night. the
Oh,
8th.
yes, you're correct.
Okay, so you showed it to both the City Council Committee and to a community group?
No, this is the one that was prepared for the Issaquah Highlands community, and I believe I had a separate presentation for the Land and Shore Committee.
Okay, well, let's turn to, if you would please, towards the back. It's the fourth page from the back called vesting. You see that?
Almost there.
And why don't you read the first bullet point to us?
The first bullet point?
Well, whatever you want to call that, the
Okay.
first signaled statement there.
The development agreement does not provide regulations or guidance on vesting of projects.
You knew for over 20 years that the vesting agreement did provide regulations on vesting of projects, did you not?
Yes, I imagine that this was shorthand to indicate what happened following the build-out period.
Is that what it says, Ms. Sloman?
I believe the words are here, and it says guidance on vesting of projects. Within the context, though, of ending the development agreement, as the title slide indicates.
Okay. Ms. Sloman, you told the city council and the community that the development agreement that you had been familiar with for over 20 years and that expressly provides regulations for vesting did not provide those regulations, correct?
Not related to ending the development agreement.
I'm sorry, what?
Not related to ending the development agreement.
You presented this slide on multiple occasions, did you not, to the city council before it ended the development agreement, telling them that the development agreement did not provide regulations that it does provide?
Mr. Chairman, I'm going to respectfully object. That's an argumentative question, and Ms. Sloman has already essentially answered the question.
Okay.
Unless you're directing the witness not to answer, then I think I'm entitled to an answer.
I don't think she needs to, I think she's answered that.
Why did you put this language in the PowerPoint that you showed to the community and the city council?
I think that we were trying to explain a relatively complex and variable concept of vesting to a lay audience.
Do you consider the city council a lay audience?
Well, they are not acting as attorneys. We have a range of very smart professional people. However, this is clearly a complex legal argument since we are here.
Well, there may be other explanations for why we're here than the complexity of the legal argument. But, okay. So do you want to provide any other explanation than you've already given for why you told the city council the development agreement does not provide regulations on vesting?
No.
Mr. Lell asked you twice whether you had ever told my client or anyone else that they were permanently vested, correct? Do you remember?
I know he asked me that. I don't remember how many times.
Okay. And what was your answer?
That, no, I hadn't.
Okay, so what is permanent vesting?
So I made an assumption that permanent vesting would be vesting that was established in such a manner that it was not open for the council to make a policy determination on.
Well, explain to me permanent vesting as opposed to some other kind of vesting.
I thought that's what I just did.
Well, is it your understanding that if you're permanently vested, the city council can't take it away, but if you're not permanently vested, they can? Is that what you're telling us?
I'm not saying that they can take it away. There are things like if you've submitted a building permit, it is established through state law that you are vested, and language that the council could choose would not be able to impact that vesting.
The state law also says you can vest pursuant to a development agreement, does it not?
Yes.
Okay. So again, will you agree that you and Mr. Niven both repeatedly told my client that they could vest to the development agreement and that the termination of the development agreement would not affect their vested rights?
I don't remember making those statements.
You remember Mr. Niven making those statements?
That it would not terminate with the development agreement, I do not recall him saying that.
This is S13. Take a look at that while we bring it up on the screen, please. Are you familiar with S13?
No. I mean, I may have seen it. This is a letter from Keith Niven to Nick Abdelnour. I'm not CC'd on it. I don't know if I have received it previously.
Okay, well, I'll ask Mr. Niven about this if he returns to the stand, but why don't you turn to the top of the second page and read what Mr. Niven wrote.
Requirements for a complete application necessary to vest are set forth by municipal code. IMC 1801050, subsection C, subsection 1, sets forth the requirements for a complete application. When an application is submitted meeting those requirements, the application is vested and would be unaffected by any future changes in zoning or development regulations so long as the application remains active, IMC 18.04.220.d.2. This would include any changes as a result of termination of the Issaquah Highlands Development Agreement.
Okay, so we have Mr. Niven telling Polygon that vesting would not end as a result of termination of the Issaquah Highlands Development Agreement. Is that a fair characterization?
I think it's best to ask Mr. Niven what he is intending by this statement.
I didn't, that wasn't my question. I asked you if I had fairly characterized that paragraph.
So, okay, ask me the question again. Please.
Fair to say that Mr. Niven expressly wrote that vesting would survive termination of the development agreement?
Under the circumstances he's identified.
I think this would be S14 and Is it fair to say this is an email from you to Mr. Abelnauer, who wrote, to whom Mr. Niven wrote Exhibit S13?
Yes, this is the same person.
And what is the date of this communication?
December 1st, 2016.
Okay. And what do you say there at the conclusion of your first paragraph about a separate vesting summary from Mr. Niven? Can you explain that to us, please?
I'm sorry, say that again. I'm trying to look at the language and listen.
Yeah, take your time. I want you to familiarize yourself with the first paragraph and then explain the reference to a summary by Mr. Niven.
Well, this, although not marked as such, is a draft letter that was sent with the intent of trying to clarify entitlements and infrastructure allotments associated with their property. This was not finalized, and so I don't know that, and I don't know that the vesting requirements, the last phrase, using vesting requirements summarized by the DSD director, Keith Niven, in a separate interpretation. I don't know whether that was issued. I don't have that document.
Well, first of all, why don't you turn to the last page of Exhibit C14. There's an approved stamp.
Right?
Is that your stamp?
Yes.
So you approved the content of this, correct?
Initially, yes. Then there was a determination around this time. We recognized that Shelter Holdings had some property. Nick Abdelnour had some property as a representative of Polygon. In response to this, we received many questions and clarifications, and at the time determined not to follow through with it.
Are you saying this document wasn't communicated to Mr. Young or Mr. Abelnauer?
It was sent to them, but we never received, I don't believe that we received signatures back from them, and so it was never fully executed.
Well, yeah, I'm not asking about that, but you sent this, you approved it, and you sent it to Mr. Abelnauer and Mr. Young, correct?
It would seem so. I assume that.
Okay, and the Exhibit S13, the one I handed out before this, where Mr. Niven says that vesting will survive termination of the Issaquah Highlands Agreement, that's the only vesting summary by Mr. Niven that we have seen in response to Exhibit S14. Are you aware of another one?
I did not, that was the director and the city attorney's purview, and I am uncertain of which documents were produced around vesting, so I couldn't attest to that.
Okay, all I'm asking for is your personal knowledge. You're not aware of any other, correct?
I don't know that. There were other applicants who were asking about vesting as we came to the conclusion of the development agreement, and I directed them to Keith Niven, and I don't know what the outcome of those conversations were.
What is the West Main problem?
I'm going to respectfully object. That calls for a legal conclusion. I believe that we addressed that during our previous testimony and our previous objection, which I believe the commission sustained.
Ms. Sloman has testified to the City Council at the Land and Shore Committee about the West Main problem. So she has historically spoken about it in public, and I think I'm entitled to ask her about it. She made representations about it to the City Council, and we can play the tape if we need to.
I do not remember providing any level of detail. That was predominantly the city attorney and Mr. Niven. I may have referenced it in a slide, but I am not a lawyer and am uncomfortable in this setting being responsible to characterize legal decisions.
Okay, well, my suggestion, if it's okay with the commission, is we do have a video excerpt from the council member, from the council meeting where Ms. Sloman talked about this issue. We can take a short 5-minute break. We can set that up and we can finish,
Are
I
we
think.
still going to be asking her to make a legal decision? Is that the ultimate
I'm not
end of
asking her
this?
to make a legal conclusion. I'm asking her to testify about issues she's already testified about in public.
And again, Mr. Chairman, to the extent that the council's question is what is the West Main problem, that is inherently a request for a legal conclusion, and this lay witness should not be expected to answer that or be able to answer that.
Well, the city has repeatedly stated that it was allowing applicants to vest when they applied for land use permits because that was compelled by the West Main case. Ms. Sloman made that representation to the city council, and Ms. Carey has informed me that we can play the videotape right now. I think it would be helpful to refresh her recollection with what she said, and then we can ask questions based on testimony she has already given in public.
Commissioners?
Yeah, I think we should see the video. I think we should constrain the questioning so that it doesn't ask the Ms. Sloman to reach any legal conclusion about that particular case, but without seeing what I was referring to, it's difficult to.
Okay, we'll watch.
Thank you.
And we will use the same caveat that Mr. Brennan offered, that, or Commissioner Brennan offered, that we aren't going to be asking her to come up with legal conclusion.
Well, and I understand the ruling, but I have to respectfully object because Ms. Sloman, in her capacity as the land use manager, has repeatedly had to make decisions about vested rights in the law. And I'm simply asking her about the scope of her own activities in her position with the city. Everyone recognizes she's not a lawyer, and her opinions are those of someone in her position as a senior planner. But I think I'm entitled to ask questions about how she interprets and applies the city code and why she does so.
Okay, we'll see.
So just for the record, before I play this, this is a YouTube video from the Issaquah City Council Land and Shore Committee. It's dated November 21st, 2017. And we're starting at the hour 09:11 mark.
We are specific that we only are vesting the ones that are vested by state law. Now, there was some concern or discussion around West Main versus Bellevue, which is a land use law case, that if you have linked permits, that those permits become vested. So in our case, to submit for a building permit, you have to have an approved land use permit. So there was a concern that, I think that was part of the thinking about with the moratorium, why certain permits were included as part of the vesting.
So if Ms. Sloman could return to the stand, then please. And before I resume the questions, let me offer one more exhibit, please, which is another PowerPoint.
This would be S15.
So is S15 another PowerPoint that you presented to the Land and Shore Committee?
Yes.
Is that on the same date as the video we just saw?
I guess so. I wasn't really paying attention to the date of the video.
Okay. And I would like you to turn, when you're ready, to once again, it's the fourth page from the back, called Vesting, Topic 4.
Yes?
Okay, so I'm not sure what I should call them, but for want of a better word, I'm going to call them bullets. The fourth bullet down says West Main versus Bellevue, land use required for building permit. So is this the topic you were just speaking on?
Yes.
So can you explain what this means in the city of Issaquah, or what it did mean?
I think that what this was speaking to is the point, the land use case. We were not speaking as much about the city, I believe. There was a separate, I don't have my materials here, but I believe there was a separate city attorney memo related to that, and I was simply setting that up for the council committee.
Well, it's fair to say, is it not, that in the city of Issaquah, one has to have, your department requires, let me phrase it that way, that one have a land use decision before one can apply for a building permit?
That isn't consistent with the IMC provision.
That's not my question, Ms. Sloman. My question is that your department, does it not, requires applicants to have a land use decision before they can apply for a building permit?
If the city code says that you can submit a building permit at any time, then you can submit a building permit at any time.
Ms. Sloman, we're in another pattern where you're refusing to answer my question. My question is about the practice of your department. Your department refuses to accept a building permit without a land use decision preceding it, correct?
I am unaware of a circumstance in which we have refused to accept a building permit because of a land use permit.
Would you turn to Exhibit S9, please? It was introduced last time. And the second page of that. The first page of this document says, commercial and multifamily building permit submittal requirements, correct?
I'm sorry, you said the first page says that?
I went back to the title of the document on the first page. Is
Yes,
that accurate?
that is the title of the document.
Okay, and then the second page, which is what is on the screen now, what is the first item required under pre-submittal?
Land use permit notice of decision has been issued.
Okay, so this is the document that you provide to applicants trying to submit a project in the city of Issaquah, correct?
These are the submittal requirements available on our website.
Okay.
Can I speak to that?
You can answer any questions your attorney wants to ask.
Okay.
But right now, I would like to turn to Appendix L again of the development agreement, which is City's Exhibit C28.
Okay.
So what kind of pre-application, before I ask you about this document, what kind of pre-application process did you require of IHIFC before you would accept any application for a subdivision or a site development permit?
So initially, we told your client that they needed to have a pre-application meeting. And we, I believe, did that with the preliminary plat. I believe that. I'm not entirely certain. Then with the land use permits, your client questioned that requirement. And initially, we identified that we thought it was necessary. Then we conceded that it was not, which is, there are indications that we did not require those, and yet your client proceeded with them.
Okay, when and how did you tell my client that they weren't required to go through a pre-application process before they could commence the procedure in Appendix L?
I'm sorry, was that positive or negative, that we required or did not require?
I'll rephrase the question. When and how, I'm trying to get specific about what you just said. When and how did you communicate to my client that they weren't required to go through the city's typical pre-application process? And by that, I mean a collaborative meeting and a pre-application process.
I don't have that email. I believe Mr. Niven spoke to that in his testimony last time, that each of us seemed to remember an email. We have not attempted to locate that email. I would add, though, that with the retail land use permit, your client submitted that permit for review on November 22nd. Our letter identifying the ways in which it was insufficient was issued on December 1st. It did not include the fact that a pre-app had not taken place, because that pre-app did not take place until December 5th. So as we went through the submittal requirements, we were not calling out that particular item.
Okay, so Ms. Sloman, the narrative you just gave was not responsive to any question that I asked. So please answer my question, and you can testify about other matters when Mr. Lell is asking you questions. Is it not accurate to say that you required IHIFC to go through your department's typical pre-application procedures before you would allow them to even submit an application?
Initially, yes.
Sorry?
Initially, yes.
Okay. And you're saying at some point in a document that you haven't, or at least here tonight, can't identify, you told my client they were free to go ahead and submit without going through that process?
My memory is that there was a form of communication. I believe Mr. Niven testified that it was an email in which we agreed that they didn't have to do it. It might have been a verbal. I have not gone back through my records. I'm just identifying there was another method in which we did not hold up your client's permits based on the need to complete a pre-app.
So when, during the pre-app process, did you send this email or give this oral communication that they didn't have to go through the process they were already in?
I don't know. I would have to go back to my notes or emails to determine that.
It's fair to say, is it not, that the timelines that you prepared, both the one you prepared for the City Council and the timeline that you prepared for this hearing, which is the city's Exhibit 27, those both commence with the date of complete application and say nothing about the months of pre-application procedures that preceded that, correct?
That the timelines that I showed did not indicate a pre-app? Was that your question?
It did not indicate a pre-app or any other pre-application process, such as a collaborative meeting?
The timeframes that are shown in, on the either C-27 or the document that we prepared for council were from the date it was submitted until, in a straight sort of time, application of time, when it could be approved. We did not show any of the steps associated with that particular process.
Is it also fair to say that either in Appendix L or anywhere else in the development agreement, is there any kind of requirement for a pre-application process?
In looking at the Appendix L chart C28, that is shown as optional.
I'm going to insert myself here, and we've been going for a long time. It seems like not a bad appropriate point to take a 5-minute break. So if you'll indulge me with that, I would appreciate it.
No objection, thank you.
Thank you. All right. I appreciate that. Short break, and I think we're ready to resume.
Okay, Ms. Sloman, could you turn back for a moment, please, to Exhibit S1, the first exhibit in the smaller of the two packages you have? So the copy, again, of the notice the city gave of IHIFC's plat application.
Okay.
And again, turn to the second page, which is the plat map that you gave notice of to the community.
Okay.
So my understanding from your testimony and that of Mr. Niven is that this is not the application that you're going to process because the building footprints and parking areas and so forth were not shown on the original application. Is that correct?
Yes, and are not part of a typical preliminary plat. It's for subdividing land, not establishing building placement.
Well, if this is not the application you're going to process, did you ever provide corrected public notice that you were going to process a different application?
No, not at this time, because we are waiting to continue until the plat is resubmitted.
So when did you decide that you weren't going to process the application that you gave public notice of in December of last year?
So the notice used, I assume that the planner grabbed the more recent plan and included that in the notice of application. That was not the original submittal. It was a submittal that your client made of their own volition, not responsive to any comments that had been received. And so I think that once we realized that was the nature of the materials that had been received, we determined that that was inconsistent with a preliminary plat. I don't know specifically the date of that.
So when are you going to give revised public notice that this is not the plat application that you're processing?
I would assume that when we send notice for the public hearing associated with the plat, that we would revise that and make that notice.
So where in the city regulation does it say that, in the city code or anywhere else, does it say that you're not going to process the plat that the applicant submits to you before you give public notice?
I think our intention is to process the plat that was deemed complete.
Well, the city code expressly allows all applicants to supplement their original applications after they're deemed complete, does it not?
I don't know that off the top of my head.
You're unaware that an applicant, by express provision of the city code, can supplement its materials at any time?
I don't know that that's overtly stated in the IMC. That's the way I understood your question.
Okay. Isn't that, in fact, your department's practice, that you allow an applicant to supplement their application with additional materials?
I would say that is an unusual circumstance. Most applicants, when they are submitting materials, are submitting them as a response to comments that they have received.
So how and when did your department decide that my client, this is a different question than the last time, that my client was not vested to the plat application that you gave public notice of?
How and when did we decide that your client was not vested to the application they gave? Was that your question?
Mm-hmm.
Well, they had a complete submittal in August, and in December, changed their proposal. That was the description that was selected when these new materials were submitted.
Well, that description they selected was one that your website required them to select, was it not?
I don't, it may be an option that is provided. I am not an expert on submitting plans through mybuildingpermit.com, but it is, I don't review lots of plans, but the more typical one is response to request for resubmittal or something to that effect, which was shown on one of our previous exhibits. That is, I think, a much more common reason for resubmittal that is selected. What your client or their consultants selected was a change in the original proposal.
And my question is, or my point is, that the website that you require applicants to use requires an applicant to choose among a set of reasons that are on the website. The applicant can't write their own description of the reason, correct?
That may very well be true. I don't submit applications, so I'm not familiar with how that part of the process works.
Okay, so what are the changes that my client made to its application between August and December that made you decide they weren't vested?
What do you mean by they weren't vested?
Weren't vested to the SDP application buildings that are depicted on. You're going to hear testimony, I assume you're aware of it already, Ms. Sloman, that these buildings are consistent with the SDP applications. So, and you've obviously decided, the city has decided that we're not vested to the development agreement because you're putting us through a process that doesn't exist under the development agreement. So when did you decide to process this application submitted in August of last year under regulations that were adopted in March of this year?
I'm not entirely understanding your question. We are processing the plat application that was submitted in August, which subdivides properties, shows rights-of-way, lot lines, legal descriptions, which is consistent with a plat. It appears that the December submittal was combining the purposes of a site development permit with a plat application.
Wasn't, in fact, the application that we see here that you gave public notice of updated in response to comments from your department that wanted to see the relationship between the SDEP applications and the plat?
If that request was made, I don't know about it. I'm not saying it didn't happen, I just don't know.
Okay, and again, if you don't know the answer, you can just say that. But my question is, when did your department decide to process this application submitted 15 months ago under regulations that were adopted in March of this year?
That question is confusing to me. The plat is being processed under, consistent with the April 4th letter, which talked about vesting related to the plat, the extent to which the plat is vested, and I'm just confused by your question.
My recollection is that Mr. Niven testified that he decided in March, when the replacement regulations were enacted, that our applications, IHIFC's applications, would be processed under the replacement regulations. Is that your understanding, if you have an understanding?
I thought that was related only to the site development permit and the administrative site development permits. The plat would use the development agreement to the extent that the plat is vested to particular regulations.
Okay. So if, in fact, the plat that the city gave public notice of is entirely consistent with the SDP applications, then why isn't my client vested by virtue of the plat to the development regulations?
I'm
Or the
sorry,
SDP?
I don't understand your question.
Well,
Are you saying because we used this drawing in error that, I'm sorry, I don't understand your question.
okay. We'll move on. Why don't we turn on to, I have the last two more. Excuse me just a moment. Okay, back to the plat and the exhibit S1 for a moment. So if you're treating, you and your department are treating the December 15, 2017 application as a separate or new application, what have you done to process it as a separate or new application?
I don't believe that we are treating it as a separate or new application. I believe we are processing the one that was submitted in August.
Well, what have you done to reject or comment on or in any way communicate with my client about the December 15th submittal? You tell them you're not processing it.
Again, I am not the planner. I know that there was one comment that we included as one of our exhibits last time, C10. And that said that there were that the information in Note 7 was, needed to be revised or something to that effect. I can't really read the words up there. And I believe that in other communications, it may be through the various venues that we are seeing each other, that we have communicated that the footprints are not part of the preliminary plat.
Well, Ms. Loban, my understanding is Exhibit C10 is the original August 1 plat application. Do you disagree?
Well, I believe last time, one of the things that we discovered that is my supposition. However, I don't believe there's a date on here. When we were looking last time, I could not find a preparation date, so I could not confirm that.
Well, if you can't confirm whether this was part of the original application or a response to the December 15th submittal. Is it fair to say that you can't confirm that this was a response to the December 15th submittal?
As I am not the planner, and on this permit, I have primarily been focused on responding to the comments, and I have not studied the responses that were sent out on the plat to be able to adequately respond.
All right, we have 2 more exhibits, and I think we'll be done.
Should be S16.
What is Exhibit S16?
I believe it was one of a series of letters that we sent to Ms. Heim and the applicant for each of the land use permits, asking them to be updated to be compliant with the replacement regulations.
And I agree, you sent similar letters regarding all the applications, and you signed or approved or initialed the letter on the last page?
Yes.
And would you read for us the paragraph at the bottom of the first page, please?
If your position is that the replacement regulations are not applicable to your permit application and you review and make the modifications referenced above, please confirm your intent to this effect in writing at your earliest convenience. In that event, the city will proceed expeditiously to issue a final decision on your permit based upon the application's compliance or non-compliance with the replacement regulations.
Okay, I'm handing out Exhibit S17. Is S17 Tia Heim's response to S16?
Yes, I believe it is.
So what's the date of the 2 letters?
May 25th and May 31st.
So she responded 6 calendar days later?
Yes.
Okay. And what did she say in her May 31st response about whether they were going to revise the application to comply with the replacement regulations?
IHIFC declines to revise its applications to comply with the replacement regulations.
Okay, then going back to Exhibit S16 for a moment, and the paragraph you read at the bottom of the first page about the city expeditiously issuing a final decision if my client wouldn't revise. Explain what the city has done to expeditiously issue a final decision between May 31st and today.
Following the receipt of your letter, your client's letter of May 31st, my understanding is that negotiations began on how to process what was understood to be a denial, and the venue, the nature of that, what the rules of the proceedings would be. That staff report was issued in September, and we have proceeded to process those staff reports.
You said negotiations commenced. Who was negotiating with whom about what?
I don't know exactly. As I understood it, I thought the city attorney and you were speaking about those matters.
Okay, well, I'm asking you what you have knowledge of, and what was there to be negotiated?
I have never been in this circumstance before, where an applicant declines to comply with adopted standards, and we are asked to process those permits, where it is essentially a court proceeding in front of a development commission. I was not clear the best way to proceed or how that would happen. So as I understood it, there was discussions taking place.
Well, when was the decision made by your department to send these applications to the Development Commission?
I don't know exactly when. There was a discussion that I had at some point with Keith Niven, who is our director, and he pointed out that under the development regulations, these would go to the replacement regulations, it would go to the Development Commission. And I don't remember when that conversation took place, but that was the point at which I realized that this was going in a different way than I had initially expected.
Can you approximate the month when that conversation took place?
I believe someone has said to me that that took place in July or August, but again, I have not looked at email to see if there is a way to identify exactly when that happened.
Okay. So can you identify anything other than what you've assumed about conversations between the city attorney and me? Can you identify anything else your department did to expeditiously process the applications after May 31st?
I think we were awaiting direction because, as I said, this is not a familiar process to me. As soon as the decision was made, we began to compile the staff reports.
When did you start work on the staff reports to send this to the Development Commission?
Again, I don't remember that exactly. I think it may have been sometime in August in anticipation of a September hearing.
Did anything at all happen in June or July?
Just the matters that I'm talking about that I previously described.
That your assumptions about communications that you weren't a part of? I'm asking you whether there's anything you know as opposed to assumed about anything the city did to get us from May 31st until staff reports in September.
So I know that there were some conversations that took place between, and I may have been in some of those conversations. I don't remember them with enough detail to describe them.
Do you recall who the conversations were with that you're recalling?
They may have been with the city attorney, and they may have been with Keith Niven, or they may have been between Keith Niven and the city attorney. I just don't remember with sufficient detail to feel confident in describing a sequence.
Okay, thank you. That's all I have.
So, right. So it's your opportunity now for indirect.
Thank you, Mr. Chairman. I would respectfully request a 10-minute break to discuss our redirect examination, which I
Redirect.
anticipate to be probably half hour to 45 minutes long.
Okay, is that acceptable?
That's acceptable. I hope we can also have Mr. Niven come back and testify about the exhibits the city introduced tonight, so we can get that out of the way before we start our case, which we're prepared to do immediately tonight.
I'm happy to call Mr. Niven again with the understanding that his additional testimony tonight would not be considered our opportunity for rebuttal testimony, which we intend to present following the case in chief of the applicant.
Okay, so you're agreeable that Mr. Niven could come and respond to Mr. Schneider's comments on 33 and 34?
I haven't discussed that with Mr. Niven, but I believe that would be permissible. Yes, thank you.
Okay, so let's proceed with that.
10-minute break.
Let's take a 10-minute break first.
Thank you.
Sorry.
Thank you, Mr. Chair.
You're welcome. Okay. Well, we're back in session. So as I recall, before the break, we decided that Mr. Niven would come and be responsive to C33 and 34. Is that correct?
Redirect. Yeah, we're going to do redirect.
Whose understanding was it going to be after Ms. Sloman's redirect?
All right. Sorry, I had it the other way around. So I'm flexible.
Ms. Sloman, I'd like to ask you a few questions as a follow-up to your testimony on direct examination and also with respect to the questions that Mr. Schneider asked you. First of all, in your experience, is there a practical difference between processing a land use permit independently versus a land use permit that is dependent on a pending or unapproved plat application?
Well, it just leaves a lot of variables on the table that you don't know exactly what may come out of the plat process that could eventually impact something like a site development permit.
Okay, thank you. And draw your attention to city exhibits C16 through C22. Those were the sufficiency determinations. Do you recall those documents?
Yes.
Thank you. Could you please describe the impact, if any, that those issues identified in those letters had on the time frame for the city's processing of the ASTPs and STPs that IHIFC had filed?
Well, as I mentioned in my testimony last time, the retail SDP was submitted in November, the medical office building was submitted in November, and we went through, I think, 4 submittals prior to reaching the agreement that was signed in March. So there was review and writing of those letters to identify if they were sufficient or not. In this case, they were not. With the storage building, I believe that there were 2 submittals and therefore 2 letters prior to the agreement in March.
And my understanding from your testimony is that ultimately the determination of completeness regarding IHIFC's SDP and ASDP applications was made through the letter agreement executed by Mr. Mullaney and the city on March 15th. Is that correct?
The letter was dated March 15th, but I think the last signature was placed on it March 18th.
Could you describe the process of how that letter was ultimately negotiated and executed?
So I believe my memory is that, there was a point at which understandably the applicant was frustrated. They were making submittals and were unable to be deemed sufficient. Mr. Mullaney, also from Foster Pepper, had spoken with Mr. Niven. Then he spoke to me. He and I discussed at some length some of the challenges that we were facing in trying, in not having certain pieces of information decided, but they were more concepts, as I mentioned. And so we agreed that we would try and write up an agreement that would resolve this in a way that preserved both parties' needs so that we could move forward.
Did the city work cooperatively with Mr. Mullaney in coming up with that agreement?
Absolutely. I mean, we thought that was a good solution to try and get out of the submit, write a letter, submit, write a letter.
Would you characterize that negotiation and execution process that culminated with the March 15th letter as being amicable?
It seemed that way to me.
Thank you. Did you ever, or did the city ever, quote, refuse, end quote, to process IHIFC's STP or ASTP applications?
I would not use that word. We were trying to get applications that were complete so that we could continue our review. And then we hit the roadblock of not having them updated to the replacement regulations.
I'd like to call your attention now to applicant's exhibit S11. This is the lengthy email exchange between your office and Tia Heim, which in the exhibit terminates with the October 10th, 2018 email from Ms. Heim to yourself.
Yes.
CCing Mr. Schlepp and Ms. Lynn.
Yes.
Is this email thread currently ongoing?
Yes, we're in the process of preparing our response.
And what's the current status of that again?
As I said, I think we're quite close to being able to issue it.
Okay. Could you please call your attention to the very last page of that email exchange. This is an email from Mr. Ken Shipley to Mr. Schlepp and Ms. Lynn as primary recipients on April 13th of this year?
Uh-huh.
Okay. As of that date, had the replacement regulations already taken effect?
Yes.
Thank you. I believe Mr. Schneider asked you several questions regarding the IHIFC preliminary plat that is pending and the extent to which the city had asked questions or raised correction issues for that submittal. In your experience, Ms. Sloman, is it normal for plat applicants to ask as many questions as IHIFC has throughout this process?
No, we usually, it's just been a lot of questions, and they have continued to expand. I mean, we're trying to help provide the information they need, but they have continued to become broader.
Has that back and forth that you just described impacted the city's time frame for reaching a final decision on the preliminary plat application?
Yes, we can't proceed till we get a resubmittal.
Thank you. Have you attempted to address the questions that have been raised by IHIFC in good faith?
Yes.
Okay. I'd like to now call your attention to some of the questions that were asked concerning the polygon applications. And do you recall that testimony and Mr. Schneider's questions?
I believe so.
Okay. First of all, was Polygon issued any sufficiency determination letters from the city?
Not that I'm aware of, but I wasn't the only planner on these permits.
Okay. I'd like to introduce into evidence Exhibit C35.
Do them all?
First, just be C35.
35, okay.
Thank you.
Thank you.
Ms. Lohman, can you please identify this document and specifically the top communication, the most recent communication?
It's an email from myself to Keith Niven.
Okay. Could you please read aloud the first 5 lines of that email?
Likely nothing you haven't already thought of. This is in response to Keith's question of thoughts. My first bullet is, while we can say that we do or don't agree with vesting, in the end, only the council can do that. Hard to say what their reaction will be to accepting the draft language.
What was the context of that communication?
Well, I think that we were, I think mostly we were trying to respond to Ms. Himes' proposal around minimum FAR, having a variable FAR on various lots.
Perhaps we could get some indication of how this is responsive to the direct. It's not clear how this has anything to do with the direct, or with my cross-examination. Can you tell me where we're going with this?
I will conclude on this document fairly quickly, Mr. Chairman, but in answer to just Mr. Schneider's question, this deals with the issue of how the city construed vesting under the development agreement and the time frame for its determination in making that decision. And I think that was a very consistent theme throughout both the direct testimony and the cross-examination.
Sounds
Thank you.
appropriate to me.
So if you look on the second page of the email, I haven't looked at this email in a long time, but the top full paragraph above the chart is Ms. Heim asking about vesting and what was going to happen to proposals, and I'm just talking about the uncertainty that existed around vesting, what the final vesting provisions that the council would adopt would be.
Thank you. I'd now like to introduce Exhibit C36. This is a Monday, November 27th, 2017 email from yourself to the entire Development Services Department, if I'm
Yes.
understanding that correctly. Could you please describe the purpose and context of this document, Ms. Lohman?
Well, I think I wanted to update the department on what was happening. We had originally thought that at December 18th meeting of the council, that the replacement regulations would be adopted. And at the previous meeting of the Land and Shore Committee, they had communicated to us that they would not be prepared to make a recommendation to do that at December 18th. And that I wanted staff to be aware that that one of the upshots of this was it would give applicants more time to vest by submitting a building permit.
Thank you.
Then characterizing what, as we understood it, were the elements that could vest.
Thank you. Could you please read the last full paragraph beginning with "this means"?
This means that applicants who are trying to vest have more time to submit BLDs, which means building permits, to definitively be vested, or land use permits to try to be vested. Only preliminary plats, short plats, building permits, and development agreements vest per state law. Staff proposed additional vesting language, which the council is considering.
Thank you. And just to clarify, since this was sent by you to the entire Development Services Department as recipients, did this reflect the department's official position at that time?
Yes, it was our understanding. I don't know that it was a position. It was our perspective on the state of the development regs, replacement regs process.
Thank you. I'd now like to introduce Exhibit C37. Could you please identify this document, Ms. Lohman?
The top email is from Craig Ramey, who is, I don't know exactly his title. He's with Regency Centers in Oregon and is the person directly overseeing Grand Ridge Plaza at Issaquah Highlands to me and Keith Niven.
And could you please identify the purpose and context of your December 1st, 2017 message near the top of that page.
Right. I'm trying to describe how vesting works, because that was Craig Ramey's question December 1st about whether Shelter Holdings was, whether their application was vested or not. And I was trying to describe our understanding of this current state of vesting to him.
Thank you. In your second paragraph, beginning with right now, can you please read the first two sentences?
Right now, other than the land use permits which the state has identified as being vested, preliminary plats, short plats, building permits, development agreements, close paren, there's a lot of uncertainty about which permit, pre-app, ASDP, SDP, close paren, would vest them. If the vesting language is removed, only the land use permits which state law identifies for vesting would be vested. Any applicant without one of those would have to start over again using the new replacement regulations, which include a minimum FAR of 1 and structured parking.
Thank you. And did that again reflect the understanding of your department at the time?
Yes.
Thank you. I'd like to now introduce City Exhibit C38. Can you identify this document, Ms. Sloman?
This is an email from Keith Niven to Tisha Geiser, who is the Assistant City Clerk or Deputy City Clerk for the city, and a CC to me.
Okay. And what was the purpose of this communication string?
Well, Tisha had originally, John Haas, who was a property, well, he wasn't even a property owner. He was hoping to purchase and develop a piece of property at Issaquah Highlands, had received one of my interested party emails February 2nd, and he had contacted Tisha asking if she would facilitate a meeting. Tisha had sent it to me, and I had responded that this was not really up to me to facilitate the meeting, and then Keith had responded trying to clarify to Tisha how a meeting, Mr. Haas or any other parties that were interested in talking about the changes that had taken place to the proposed replacement regs, how they could facilitate a meeting with the mayor.
And at the time that email was written, what was the administration's then current proposal regarding the vesting provision of the replacement regulations?
To restrict it to those items that were vested per state law.
Thank you. I'd now like to introduce exhibit number C39, please. Ms. Sloman, can you please identify this document?
This is an email from me to Nick Abdelnour, who has a high position in Polygon Northwest, and Keith Niven.
And what was the purpose of this communication?
Well, I believe Mr. Abdelnour had read our white paper that had been sent to the Land and Shore Committee for the November 21st meeting, I'm guessing from looking at this, and had wanted clarification on what that meant about his projects.
And can you explain the basis for your response to him, beginning with the word yes?
So Nick says on November 21st, am I reading too much into this? On page 2 of the white paper, our projects were not included on the short list because the city believes and is confirming our projects, single family north, multifamily north, tract D, and block 4, close paren, are vested. And I said yes, and I'll say it again tonight when we look at unbuilt properties.
And what was the basis for your conclusion? or determination in that response?
That the properties that he referenced had either a building permit, a preliminary plat, or were related to the development agreements that we have talked about before related to affordable housing and all those documents.
Thank you. I'd like to introduce exhibit number C40, please. Could you please identify this document?
It's an email from me to Richard Rawlings, who is also at Polygon. I don't know his title, as well as CC to Nick Abdelnour at Polygon, and David Avenel at Polygon, and Jennifer R. Woods, who is a city staff person.
Thank you. Could you please quote the second paragraph of your November 3rd, 2017 response to Mr. Rawlings, beginning with "as for"?
As for your Westridge properties, they are all vested under the IHDA due to the development agreement. While I appreciate your insights into the proposed standards, most won't apply.
Okay. What was the basis? Excuse me. Could you please repeat the last few words so that the court reporter
So I'm
can
going to read the
accurately
last
transcribe them?
sentence again. So while I appreciate your insights into the proposed standards, most won't apply. Most won't apply.
Thank you. And again, what was the basis for this response?
By development agreement, I meant the documents that had been recorded in association with the TDRs and affordable housing with the Polygon properties.
Thank you. I'd like to call your attention to the applicant's exhibit S9.
Yes?
Mr. Schneider's questions to you regarding this document?
Yes?
Okay. I believe you indicated that you've been employed by the city of Issaquah for several years, and you have been a consultant for the city for even a longer period. I'll defer to your actual response, but I believe it was at least since 1996 or thereabouts?
Yes.
Okay. In that period, Ms. Sloman, has it been your experience and observation that the city of Issaquah rigidly enforces the pre-submittal requirement listed on page 2 of this document for a land use permit notice of decision to be issued before a, do you see what I'm referring to?
Yes.
Okay.
The submittal requirements are not code. They are based on code. They are based on the things that we have to review, but they are more like a guide. We have the ability to ask for the things here, but we go through this list and review it with applicants. Not every applicant, but often applicants will ask us to go through and say, do we need this thing? Do we need that thing? I don't think this thing is relevant to our project. Why are you asking for this? And tailor it to the project that's actually in front of us.
Do you consider that submittal checklist to have independent binding regulatory effect in the city?
No. If there was a conflict between adopted city code and this document, adopted city code would take precedence.
Do you consider the vesting provision codified at IMC 1801-050C to be in conflict with that provision of the checklist submittal requirements?
It Potentially could be, yes.
And in the event of such a conflict, which of those provisions would prevail and control?
The adopted.
I would note that Mr. Lell is asking for a legal opinion, and he's repeatedly objected to me doing that. He's also resorted again to asking leading questions.
Fair enough. I will rephrase the question.
Thank you.
Ms. Sloman, does the city enforce IMC 1801-050C over an inconsistent provision of the application checklist?
Yes.
Thank you. I'd like to then turn your attention, Ms. Sloman, to the applicant's Exhibit S12. This is a February 7th, 2018 PowerPoint presentation entitled Ending the Development Agreement in Issaquah Highlands.
Yes.
Could you please turn to item number 7 entitled Vesting, the provision that I believe Mr. Snyder referred to during his cross-examination?
Yes.
Okay. In the first
Let's call them
diamond-starred
bullets.
bullet point,
I think Mr. Snyder was correct.
I will refer to it as a bullet point. When the document states the development agreement does not provide regulations or guidance on vesting of projects, did you draft this provision? This reference to the PowerPoint?
Probably.
Or did you at least participate in the drafting of it?
Yes.
Okay. What did you mean by this reference?
Well, I think given that as the first page of S12 shows that this was in the context of ending the development agreement, that this was because we had been for months talking about what provisions for vesting or not vesting would apply as the development agreement ended. The point was to say that the development agreement did not provide guidance on what vesting for those permits that were in process, what that would be.
Do you stand by that statement today?
Sure.
Thank you. Could I direct your attention to Exhibit or Attachment 9 to the staff report that prefaces these proceedings?
Yes.
This is the excerpts or select excerpts from the Issaquah Highlands Annexation and Development Agreement.
Yes.
I believe that Mr. Schneider had asked you some questions specifically related to Section 3.23 of that agreement and 3.23.2. Do you recall those questions in your testimony?
Yes.
Okay. Are you aware of anything in those provisions, Ms. Sloman, that expressly states that an applicant is vested permanently to the standards in the development agreement?
I don't think that permanently vested is used in this document.
Could I call your attention to Section 5.13, also contained in the excerpts in Attachment 9?
Yes.
Have you read this section?
Yes.
Okay. How do you construe, or how do you construe this section in relation to IHIFC's ASDP and SDP permits?
Well, the very last sentence of 5.13 term says, upon such adoption, well, I guess I should note that above this it talks about replacement regulations. And so upon such adoption, this agreement shall terminate, and thereafter the UGA, which is the urban growth area, portion of the property shall be governed by the adopted city zoning and related development regulations.
And again, how do you construe that provision as applying, if at all, to IHIFC's ASDP and SDP applications that are at issue in this proceeding?
That if you don't have a permit that is vested to the Issaquah Highlands Development Agreement, based on the replacement regulations, that whatever zoning and development regulations are adopted become the, upon adoption of that replacement zoning and development regulations, those are then in effect.
Thank you. I'd like to return your attention to Section 3.23 of the agreement, also excerpted at Exhibit 9.
Yes?
In the title of that section, vesting of development standards and mitigation, do you see that?
Yes.
Are you aware of any other provision in the Issaquah Highlands Development Agreement that uses the words vest or vesting?
Without doing a word search, I can't say, but I know that when, in the time period in which we implemented the development agreement, since I started working on it in 1996, if someone asked me about development standards and their vesting, this would be the likely place I would start.
Thank you. But just to clarify, are you aware of any other place in the document where that term occurs or exists?
Not off the top of my head.
Thank you. And just to clarify, you've had familiarity with this document since 1996, according to your earlier testimony. Is that correct?
Yes.
Thank you. I'd like to now call your attention to applicant's Exhibit S15.
Yes.
This is the PowerPoint presentation, I believe, from your department for the November 21st, 2017 Council Land and Shore Committee
Yes.
meeting. Okay. Can you please turn your attention to Topic 4, entitled Vesting?
Yes.
Near the end of that document. Okay. In the second bullet point reference, what does it mean to say at-risk permits and then followed by pre-apps, ASDPs, and SDPs?
Well, looking at, under the title, Topic 4, Vesting, it sort of begins with an introductory question of what happens to permits in review or with active land use permits. And the first bullet identifies those that state law vests. And then the second bullet identifies permits that are at risk because they are not covered by state law.
Thank you. So this was a PowerPoint presentation on November 21st, 2017.
Yes.
And was the Council Land and Shore Committee meeting that date open to the public?
Yes.
Was the agenda and related materials for that meeting sent out to the interested parties?
I would send a link to the packet, the Land and Shore packet.
Were IHIFC's representatives, including Ms. Heim, included as email recipients of those materials?
Yes.
Would this document have been included in that?
No, this document was prepared as a summary of the materials that were in the packet.
Do you recall if Ms. Heim or any other IHIFC representatives attended that meeting?
I would assume so. They were very interested in the proceedings and had regularly attended all the meetings, beginning with the Land and Shore in the fall of 2016.
Thank you. The final bullet point under the Topic 4 vesting heading in your PowerPoint, could you please read that to me?
Sorry, I closed it. The last bullet,
Please.
Recommendation.
Beginning with recommendation.
add vesting language.
And what did that reference mean? What was the purpose and context of that?
Well, I think staff's recommendation was that one of the options that had been put forward over the month or two before this meeting, probably 2 months before this meeting, one of the options was to be silent in the replacement regulations with regards to vesting, and staff did not recommend that.
Why not?
We thought that it created uncertainty, and we wanted more clarity for applicants, staff, the public.
Thank you. I'd like to call your attention now to applicant's Exhibit S13. This is a March 27th, 2017 letter sent by Mr. Niven of your department to Mr. Nick
Abdel Noor.
Abdel Noor of Polygon WLH LLC?
Uh-huh.
Okay. Did you participate in the drafting of this letter?
I don't think so.
Thank you. I'd like to call your attention to applicant's exhibit, what is now termed S1. This is the notice of application for the IHIFC preliminary plat that was issued, I believe, in December of, I believe in either December or January of last year.
Yes?
To your knowledge and understanding, Ms. Sloman, is a notice of application independently appealable under the city's regulations?
No, my understanding is that it begins a process that culminates in a decision that can be appealed, but it in and of itself would not be.
Thank you. I have no further questions. Actually, I'm sorry, pardon me. Did you have anything else that you wanted to clarify, Ms. Sloman, from your original testimony or your cross-examination testimony from Mr. Schneider?
Well, I guess Mr. Schneider did not, he didn't find it responsive to his question, but I know that one of the questions that we have focused on is the pre-application process. I think that the city had started by saying that they were necessary and then conceded that they weren't. When you look at the processing of the various land use permits, when the pre-apps took place and when the applications were submitted, as I mentioned, the retail site development permit was submitted on November 22nd, 2017, and our sufficiency letter went out on December 1st, 2017. And while we identified a number of items that we felt were insufficient, not holding a preliminary pre-app meeting was one of them. And their pre-app meeting did not take place until December 5th. So if we were going to require that of them, that would have been something that we would have identified.
And just for purposes of clarification, the city originally told IHIFC that a pre-app was required, but then clarified that it was not? Was that
Right,
what you
after
said?
Ms. Heim pointed out that they should be treated as optional meetings.
So in the end, the city did not require a pre-application? is that
No,
correct?
and we assumed that they were proceeding with them because they thought there would be beneficial. We certainly found them to be helpful in terms of improving the quality of the land use submittal.
And I believe Mr. Schneider touched on this in his questioning, but I don't recall the response. How was that communicated to the applicant that you were not going to require a pre-application?
I thought that it was through an email, but I have not done any research to determine who or how we conveyed that.
Thank you very much. No further questions, Mr. Chairman.
Okay. So, Mr. Schneider, I think you have a chance now to address specifics to the new material that you've just received.
Well, much of the new material we just received, I think, goes way beyond the scope of any questions I asked, and it's remarkable that all these exhibits can be put together in 10-minute break. This is, I think, clearly an introduction of new evidence and new issues. And it's going to take me a while to go through these documents. They're beyond the scope of anything I went into. So again, I suggest in terms of efficiency, we break here. I've got, 10 new documents to look at and figure out how they're relevant to this. I can go ahead and get started, but I don't see any hope of being done by 10 with all of this new information in the record.
And the city does not have any objection to breaking at this point, with the understanding that Mr. Niven would come back at the next meeting to discuss the Polygon materials.
Okay.
Well, we can certainly do Mr. Niven's testimony tonight, but I think it'd be more efficient for everyone if I have a chance to look at these new materials.
No objection.
Okay, so let's proceed with Mr. Niven's discussion of attachments 32 and 33, 33 and 34. Is that correct?
33 and 34.
Okay.
Zach, are you going to ask questions, or?
Very briefly, if I could, Mr. Chairman.
Okay.
Thank you. Mr. Niven, could you please acknowledge for the record that you continue to be under oath from your earlier testimony?
I do.
Thank you. As you're aware, the city introduced into evidence tonight two documents labeled Exhibit 33 and 34. Are you familiar with these materials?
I am.
Okay, thank you. Could you briefly describe Exhibit 33, C33?
So Exhibit 33 is a development agreement with Polygon Northwest, and it relates to the provision of affordable housing units that was associated with the transfer of development right agreement that the city approved for Issaquah Highlands.
Okay. And when was this document executed?
It was recorded in January, let me see, the 27th of December, 2017.
Okay. Thank you. What was the purpose and context of this document?
The purpose of this document was to obligate the terms by which Polygon would provide affordable housing as part of its development of two different neighborhoods in Issaquah Highlands. That was part of a development agreement amendment for Issaquah Highlands because they had purchased 100 TDRs, transfer of development rights. Sorry for the acronyms.
And what is a TDR, or transfer of development right, just for the record?
So transfer of development rights, so the city has a code which allows, which creates both sending sites and receiving sites for transfer of development rights. One of the sending sites was development on Tiger called Park Point, and all of those development rights except for 100 were used up previously by Port Blakely. The remaining 100 were purchased by Polygon Northwest, and they sought to move those, to actuate those 100 transfer of development rights in property they owned in Issaquah Highlands.
Thank you.
So the city started a conversation with them about that and about amending the existing Issaquah Highlands development agreement to allow an additional 100 residential units.
Could I please turn your attention to page 7, section 4 of this document?
Yes.
Could you please read that aloud?
Yes. So section 4 is titled Covenant Running with the Land, Enforcement. And it reads, "This agreement shall constitute a covenant running with the land and shall inure to the benefit of and be binding upon the parties and their respective heirs, successors, and assigns until terminated as provided in Section 5 of this agreement. The covenants and restrictions contained herein shall benefit the city, and the city is hereby granted full authority to enforce this agreement by any means available under the law."
Thank you. What's the purpose of that section, as you understand it?
The purpose of this section is to identify that this document was executed to the benefit of the city between the parties that executed it.
And could you read aloud section 5?
Yeah, Section 5 was the section I clipped in the exhibit
Yes.
that I provided last meeting to try and explain why Polygon was treated differently. Section 5 is titled Termination, and it reads, "Upon the final sale and closing of the affordable units as provided in this agreement, then the city shall, at the owner's request, execute a document in recordable form in substantially the form of Exhibit F, paren termination agreement, that so states and recites that this agreement and its covenants are therefore terminated. The owner shall pay all fees and charges incurred in connection with any such recording."
Okay. And I believe that this Section 5 was excerpted and included in a previous exhibit that was submitted. Do you recall that?
I do.
What was the purpose of that?
The purpose of that was to provide an explanation to the applicant why Polygon Northwest was allowed to continue to develop its parcels under the Issaquah Highlands Development Agreement.
And so I'm clear, are you saying that the part of the reason was because the city had undertaken this contractual obligation? Was that what you mean?
Yes.
Okay, thank you. Could I please turn your attention to Exhibit C34?
Yes.
This is a development agreement. I think that you answered some questions about this previously, but could you please describe this document?
Yes. So this document was basically the document that we took through the city council and identified the parcels. You can see the exhibit, which is labeled Attachment 2 on page 6. Those are the two parcels that we've been discussing that are owned by Polygon. It also then, if you move on to Attachment 3, we provided a valuation because ultimately what was being requested was that a city-owned parcel, which is Tract D, I think there's an exhibit that shows where that is here, maybe not, would be basically traded to Polygon in exchange for the affordable housing units that were identified, and that the city needed to demonstrate that there was a benefit to the public so that there wouldn't be gifting of land to Polygon through this transaction.
Mr. Niven, to your understanding, do either one of these documents, either the agreement identified as Exhibit C33 or the exhibit identified as C35, contain a defined build-out period similar to the Issaquah Highlands Development Agreement?
By C35, did you mean
I'm
C34?
C34, excuse me.
Okay.
Pardon me.
So what these documents did was they created a construct by which Polygon could actualize those 100 TDRs, transfer development rights, as part of their build-out of their property. And the city would, in return, get a certain number of affordable housing units constructed as part of the build-out of those two divisions. And so the termination, the build-out period, was basically set up so that those two neighborhoods could get built out. We would get our affordable housing, and then these documents would sunset.
Great. I have no further questions. Thank you. I would, if I could, I'd like to introduce one additional document for context into the record. I think the appropriate time to do that would be now, since it relates at least peripherally to the agreements that were previously entered as C33 and C34.
Okay.
Thank you.
This will be C41.
No further questions, Mr.
All
Chairman.
right, thank you. Mr. Schneider?
Okay, Mr. Niven, I'm trying to digest the new Exhibit C41. Did you write this letter?
I did.
Was it written by Mr. Abdelnauer instead of you?
I don't believe so, but it's been a year, so I can't say conclusively it was or was not. I don't believe he wrote this, but I don't remember.
Did Mr. Abdelnauer write any letter for you regarding the vesting of his projects and ask you to put it on your letterhead and sign it?
I don't recall.
You don't recall one way or the other?
I don't recall one way or the other.
So this is dated November 22nd of 2017, but it says it's supplementary to the correspondence of March 2017? Well, I guess those were statements rather than questions. So it refers to a new development agreement that the city and Polygon entered into. It says, based on the terms of the new agreement, that these projects are vested to the Issaquah Highlands Development Agreement, correct?
Yes.
Okay, I submit to you, Mr. Niven, that Mr. Abelnauer wrote this letter and asked you to put it on your letterhead and sign it, and that's what happened. Is that not correct?
I think I already answered that question.
Okay. So where in the So let's turn to Exhibit C33 for a minute. You referred to this as a development agreement. That's not what it is it?
I believe it's an affordable housing development agreement.
Where does it say it's a development agreement?
Yeah, it's an agreement for development.
A development agreement is a creature created by state statute that requires certain procedures to create. Is that not correct?
That is a defined development agreement by state statute, correct?
Okay. And are you asserting this document, which is called a developer sales agreement, is in fact a development agreement executed pursuant to state law?
You're going to need to say that one more time.
Are you saying that this is a development agreement executed pursuant to state law in the same way the Issaquah Highlands Development Agreement was?
So I'm going to answer the question the way I want to, and then you can tell me if you want me to re-answer it. C34 is a development agreement, which I consider equivalent to the development agreement for Issaquah Highlands. C33 is called out for as a requirement of the development agreement C34. And whether that legally has a standing of equivalence, I'm not a lawyer and I can't answer that question.
Okay, so let's turn to C34 then, and where does it call out C33?
In subsection 1E, as in elephant.
You're going to have to forgive me for a minute. Our copy of that agreement has walked off here.
Pat, would you like to borrow my copy?
Sure, thank you. Okay, so I'm sorry, which section again, Mr. Niven?
Section 1, elephant. It's on page 3, top of page 3.
We must be looking at a different document. The top of,
Well, it's the same document.
I have section E at the top of page 3.
It's section 1, and then the letter is E, under section 1.
Okay, one subsection E.
Yes.
Okay. Okay, I'm having trouble seeing why we're not in a circle here in terms of the dates and the documents. Is it not correct that Exhibit C34, the document that is called a development agreement, is an attachment to Exhibit C33?
So C33 is a requirement of C34.
And C34 is an attachment to C33?
C34 is part of C33. So C33 has attached to it the development agreement.
Okay, so what are the dates then? The C33 is recorded on January 28, 2018. C33 is executed 9/18 of 17.
C33, it's 34. This is cross-referenced. This is pursuant.
The copy that's attached to the recorded C33 is not signed. Okay, well, and I apologize, it's late, and I am having a hard time making sense of them, but let me ask you, where in either agreement does it say anything about vesting to the regulations in the Issaquah Highlands Development Agreement? It says anything about vesting to the development regulations in the Issaquah Highlands Development Agreement.
So it's the opinion of the city, as stated previously, that Section 7, or 5, I mean, termination.
Section 5 of Exhibit 33.
Yes.
You have to explain that one to me, Mr. Niven. I don't see any reference in termination to either the Issaquah Highlands Development Agreement or to vesting.
So the construct of these agreements was that Polygon could build out their properties under the existing terms of the development agreement until they finished, as it's described in Section 5 termination.
Well, again, I don't see that anywhere in either agreement. So how does the termination of this agreement have anything to do with vesting? I'm genuinely, I simply do not begin to understand. So what is the city's rationale for interpreting Section 5 as creating vested rights in a development agreement that the city terminated?
What was the city's, I'm sorry, what was the city's intent?
No, what,
How does the city interpret? Sorry, it's late, I'm trying to hear your question.
yeah, and I apologize. It seems
Yeah.
to me like I'm shouting, and apparently it's not carrying, but can you explain one more time how we get from termination to vesting?
So these agreements, which were put together to obligate Polygon Northwest to provide a public benefit as part of the build-out of their property, was put together in a way that ran with the land until that benefit was provided. And so the termination piece is addressing when basically their rules would expire. So the intent here, when we put this together, and there can be maybe a separate conversation about whether it reads that way to everybody or not, but the way that this read to the city and Polygon was that this would allow them to fulfill their obligation to provide those affordable housing units under the terms of the development agreement, which was still in effect when these documents were executed.
Well, Mr. Niven, isn't it correct that the replacement regulations allowed Polygon to go ahead and build the affordable housing?
I don't think that we ever evaluated what Polygon and the city agreed to under the replacement regulations. So I don't know the answer to that question.
You are aware their property is zoned for residential, correct?
I do.
Okay. So I don't think I have any more questions about the Exhibit 33 and 34, but in light of this testimony, I do have a couple of documents I want to submit next time in rebuttal. So, but I would suggest we terminate for tonight, talk about upcoming dates, and I just would like to reserve the opportunity to submit some additional evidence in response to this.
No objection from the city, Mr. Chairman. You may recall that the rules of procedure for this proceeding contemplated that the parties were free to submit documents and other evidence up to the close of the hearing. So the city does not object to Mr. Snyder's proposal.
Excellent. So in light of the hour, I guess this meeting is now adjourned to Tuesday, January 15th, 2019 at 6:30. And the meeting will be held in the council chambers here.
And are we also confirmed for the 16th? And would it make sense to talk about future dates as well, since we're we're not going to get done those 2 nights.
Sure.
So I think it's a question of when the commission is willing to enable
So
the meeting.
I think the way that has been most effective is staff sends out dates that are available to the commission to check on our availability, and they'll work back with you, Mr. Schneider, and your team, as well as the city's team, to make sure we can find some dates that line up. But recognizing we're trying to accomplish this at the earliest convenience that we can accomplish.
Yeah, we would, for all the reasons we've discussed, be grateful for as many dates as soon as possible.
Excellent. So with that, I guess we are adjourned. I would like to wish everybody a wonderful holiday and a prosperous, exciting new year.
Thank you.
Thank you.
Thank you.